factors. These are those factors that the existence of which will cripple or invalidate the contract. Will cripple or invalidate the contract. So these factors, when they can be seen in a contract, they are there in a contract. One of them is there in a contract. It makes the contract invalid. In other words, the contract cannot be enforceable in the court. So what are some of these vitiating factors? So these include mistakes. Number 2, misrepresentation. Number 3, duress. Number 4, undue influence. And then number 5, sometimes we call it illegality. So these are the 5 vitiating factors which, when present, makes a contract invalid. But let's take them one after the other and talk briefly about them. So number 1, misrepresentation. What is a misrepresentation? A misrepresentation is a false statement of fact or law which induces the other party to enter into the agreement. In other words, when somebody makes a false statement that makes the other party enter into the contract, then it becomes what? A misrepresentation. So let's say, for instance, you sell drinks, beverages and everything. Then I come park a car. Then I come out and I'm wearing Casa Preco t-shirt and I'm having an ID card. Then I said, oh, sir, this is my ID. I'm working at Casa Preco Company Limited. We are seeing businesses and try to sell to them at affordable prices so they can buy and also resell to others. Then he said, oh, okay, that sounds good. Then I said, okay, for you to get that offer, you must make a deposit of 2,000 Ghana cedis, and then tomorrow we're going to be bringing you your first consignment. All right. Then you're like, whoa, that sounds good. Then you wire the money to me. You wire the money to me. The following day, you didn't hear anything. Next day, where dodge. The following day, where dodge. Okay, so what do? You go to Casa Preco Limited or you call them. Then he said, oh, somebody from your company came yesterday. I paid the person 2,000 cedis. The person even gave me a receipt and I can't hear from the person. Then Casa Preco said, yeah, we don't have people going out like that now. We've not been doing that this time around. Then you're like, I don't understand. I'm taking Casa Preco to court. If you go to court, the person that you claim came to you is not an employee of Casa Preco. So you should have done your due diligence before buying the thing or before giving the person any money at the end of the day. And so that becomes what? A misrepresentation, and makes the contract invalid, so that in your mind you are entering into contracts with Casa Preco, not knowing you didn't enter into any contract with Casa Preco, and you entered into contract with somebody else who is not an employee of the Casa Preco. But the person was able to convince you. Why? Because the person makes a false statement and you were induced to fall into that trap. And we said that a statement of opinion or intention are not misrepresentation as long as the opinion is genuinely held at the time. So for instance, if someone shares an opinion, so we are entering into contract, then you asked me a question, then I said, okay, I don't have the full detail about it, but I think A, B, and C is what is the case. Then we entered into the contract. You cannot call that I induced you, I lied to you. No, you knew it, that at the time I was making the statement, I said, hey, this is my opinion. So it's not that I knew the fact and I was lying, or I didn't know the fact and I didn't take time to look at it. It's just my opinion, and you knew it and you entered into it. So if the opinion is genuinely held at the time of entering into the contract, then it shall not be referred to as a misrepresentation. Then silence. Silence will not constitute a misrepresentation as well. So sometimes when you ask a question to the either offerer or the offeree, and there is an exchange between the two parties before they go into the contract, and one party is silent, that silence may not be referred to as a misrepresentation unless one, it turns the statement that has been made to be a half-truth. So for instance, there is this generic statement that we make that silence means consent. So if you ask something and I don't respond to you, and by that you concluded that, oh, okay, then what you are saying is true, then it could be referred to as what? A misrepresentation. Then two, if the silence is concealing a relevant, conceals a relevant change in circumstances, then that can also be referred to as what? A misrepresentation. So if I kept quiet because I am trying not to open a lot, I'm trying not to tell you too much, I'm trying not to get myself trapped, at the end of the day, then what is going to be happening is that it could be referred to as a misrepresentation in that particular case. But the big question we ask ourselves is, what are the types of misrepresentation? So we said we have fraudulent misrepresentation, negligent misrepresentation, and then innocent misrepresentation. So with the fraudulent misrepresentation, this refers to a misrepresentation that is made with the knowledge of the falsity or with the reckless disregard as its truth. So here, the representee, the one making this false statement, knows for a fact that this statement he or she is making is a lie, but he makes it anyway to induce you to enter into the contract. So my example of Casapreco and somebody coming from Casapreco is an example of what? Fraudulent misrepresentation. Because the person came and knew that the statement he or she was making was a lie, but he makes it anyway and lie to you. Remember, the key thing about misrepresentation is that it should cause the other party to enter into the contract. If it doesn't cause the other party to enter into the contract, that cannot be a misrepresentation. But we said there is a remedy available. That woman who has been deceived, who has taken Casapreco to court, and the court says, Casapreco doesn't own you anything, go away, we don't have any problem with you. Two options are available. Recession. Like I say all the time, this is where the woman will say, okay, then she starts crying and starts calling things. Then Agbalagba will be thrown to you who came to lie to her. If there is anything like that, in that case, that is recession. Or if the woman is able to see you, then the woman can take you to court and can sue you for thought deceit, so that you will be able to pay back whatever 2,000 cedis he has paid you, and any legal fee that he has incurred in taking Casapreco to court, and any other damages that the court will see it or will see it fit for the particular scenario and the circumstance. So whatever it is, under fraudulent misrepresentation, the injured party is not really at loss unless otherwise the injured party tries to go for recession, in which case nothing will be received, but they can sue, or the injured party can sue, and there will be some release for the injured party. The second one is negligent misrepresentation. The word negligent means you are not careful about what you are making and you just make it in disregard. So if you are negligent about something, it means you are not reasonable about it, you are not careful about it, you don't even understand the intensity of the statement at hand, and you're just making it up. So this refers to a misrepresentation where the representee, the one making that false statement, cannot prove that he had a reasonable grounds for believing that the statement was true. That is negligent. So I made a statement, but I did not research to see if the statement I made is true. So it's more or less like an intention that I'm sharing, an opinion that I'm sharing, but this opinion is critical to the assignment, and I didn't take time to look at it because I was like, hey, we are running out of time. Can we get this thing done? Maybe later on we can check about the truity of the law relating to this particular arrangement. Boom, then you enter into the contract. It is called negligent misrepresentation. The remedies available for negligent misrepresentation is just the same as what is available for fraudulent misrepresentation. It could be a rescission, let it go, decline about it, go home, or damages as for the thoughts of deceit under negligent misrepresentation. So that is also the second one about that. Let's look at the last one, number 3, and that's going to be an innocent misrepresentation. Innocent misrepresentation. Now, this one is funny and it's very interesting. The idea about innocent misrepresentation is that unlike fraudulent, where the person knows, negligent, where the person doesn't have any reasonable ground to believe that what he's saying is true. Innocent is where the person making the false statement does not even know that the statement he was making was false. That's innocent representation. So it arises where the representer can prove that he had reasonable ground for believing that the statement was true. So that's it. You take me to court and I'm like, yo, okay, so back to Casapreco illustration that I gave at the beginning of the discussion. So let's say you took the person to court and the person said, no, I didn't lie to you, my lord, I didn't lie to this person. The reason I took that action was that I saw a publication on Facebook, or I saw a publication in the newspapers, and Casapreco announced that they are doing a program for businesses, and so businesses can come and buy goods at the end of the day, and the business can let people come in or buy goods at the end of the day, and anybody that arranges that deal, the person is likely to get some commissions coming in. Then the person said, I saw that ad, that was why I came to you, ma'am, and I took the money. And the 2,000 that I took it to Casapreco Company Limited, only for me to be told that, oh, this arrangement is no longer available, or the company no longer does that. So I didn't lie to you. I believed what I saw and I acted in the light of what I saw. So I didn't lie to you. Thou shalt not do anything serious about me. I've also lost money, probably because of that thing. I thought it was true and I believed it. That was why I came to you, talk to you, so that you will also enter into the contract at the end of the day. So that is the concept about innocent misrepresentation. So when it comes to the innocent misrepresentation, what are some of the solutions available? Just the same way as what we mentioned, there could be resertion. So the same thing, resertion and then damage for thought of deceit at the end of the day. These are the things you must understand when we talk about misrepresentation. So let's look at the second one. So that was about misrepresentation. Let's look at the second one, mistakes. Mistake is simply an error that is committed either by both parties or just one party to the contract. Either by both parties or one party to the contract. So it refers to an error committed either by a party or both parties to the contract. So the key thing here is that it is what? An error. Now, note that an error can be made on the subject matter of the contract or even on just something else. So, for instance, I say that, oh, Richard, I'm selling a phone. Then, in your mind, you thought that I was selling my iPhone. So you were like, yo, sure, I'm going to buy it. Then you asked me, how much is it? Then I said, oh, Charlie, I'm really down. I'm broke. I need some money coming in. So it's just 2,000 CDs. When you heard that, you were like, yo, okay, sure, he's selling his iPhone. I've got it, 2,000, cheap money. Let me go buy it. Then you bring the money, then I gave you my Samsung. Then you're like, what the heck? That's not what you said you were selling. No, I said phone. You should have asked, which of the phones are you selling at the end of the day? So you realize that there we have committed an error. Okay, we've committed an error. We did not understand. Whilst in my mind, I'm selling my Samsung because of how excited you are about it. So in your mind, like I'm saying, you are thinking about something else. In my mind, I'm thinking about something else. So that is what you need to understand when we talk about mistakes. But mistakes can also be put in certain types. We have what is called the common mistake, the mutual mistake, the unilateral mistake. So let's look at the types of mistakes that can be made. So types of mistakes. Number one is that we can look at it from this one, common mistake. Common mistake is where, so it is where the mistake is to the existence of the subject matter. So, like I said, I'm selling a phone. Then he said, hey, Nhyira, okay, I'll buy 2,000. You send the money. Then I did delivery for you. You open the thing, it's Samsung. Then the subject matter, it's the mistake there. So that is what we call a common mistake. 2, mutual mistake. Mutual mistake. It is where the parties to the contract, so it is where the parties are at a cross purpose, but neither aware of the facts, and there is no consensus. There is no consensus on the contract. So with a mutual mistake, it's like, it's not just about the subject matter, it's about the whole contract. Okay, I'm selling the phone, right? It's an iPhone. Then I said I'm selling it at 2,000 cedis. Then he said, oh, you should do something about it. The economy is somewhere. Then I said, oh, no, I'm not going to do anything about it. We didn't reach any consensus. Then you sent 1,500 Ghana cedis saying that, hey, we finished with the contract. As you send me the phone, you send me the money. Then I said, I was thinking that you are sending 10,500 so that later on you send the 500, then you take the phone. Then he said, that is not what we agreed on. I mean, I thought Nhyira, you said 1,500. So we are at opposite end of the deal, and we thought we had concluded on the deal. I thought this is what you meant. You thought this is what I meant. So there is no consensus that is reached based on the facts, but both parties to the contract thought they had reached a conclusion. So if you take me to court and say, Nhyira, I'm giving you 1,500, give me the phone, then I'll tell the judge, my lord, that is not what we agreed on. We didn't agree on that. Can we request for the conversation from MTN? Then they requested a conversation. Then it was established from our conversation playback that no, nobody said anything like 1,500. Nobody also said pay the 1,500 and pay the 500 later. So there was nothing like that. So that will be referred to as what? A mutual mistake. Then 3, unilateral. So it is where one party, now so uni means one, is aware of the other's mistake, which renders the contract invalid or void. So that is the idea about mistake. So this one is just one party making an error or committing an error to a contract. For instance, if a person who mistakenly signs a contract may plead for a mistake and have the contract set aside, if he can prove that there was a radical difference in what was signed and what he thought he was signing. So let's say, for instance, again, you are signing a contract and you read it. They send a document to you for 2 weeks. You've gone through it yourself, and then you came back. Then they ask, did you read everything? Then he said, fine. Did your lawyers look at it? Then he said, fine. Then they said, okay, these are the 2 contracts. Please come and put your pen here and come and put your pen there. So we sign everything. Then something happens. Then the person with you, whom you sign a contract with is moving a motion against you. Then you're like, what the heck? Are you guys serious? That was not a contract I signed. The contract he gave me, that was not it. So if you can prove that they are making a mistake, or they are giving you a wrong, they gave you a wrong form to sign, a wrong document to sign from what they had previously given you to go through, it could be seen as a mistake at the end of the day. So these are what we must also understand when it comes to mistakes. Common mistake on the subject matter: mutual mistake, no consensus has been reached. Really, however, the parties to the contract thought they had reached a contract. Unilateral mistake where only one party to the contract is committing the error or making the mistake. That's the second one. Let's go. Duress. Remember, we emphasize on the fact that one key element of a valid contract is that the contract must be entered into willfully, without force. In other words, for a contract to be valid in the court, the parties to the contract must have entered into the contract willfully, on their own accord. They've read the documents, they've heard everything, and they entered into the contract. But then sometimes, if a party enters into the contract, but a party can prove that the contract he entered into was actually a duress or an undue influence, then the contract will be considered as what? Invalid. So when we say duress, what does that mean? It is based on threats of physical violence, to coerce, to force someone to enter into the contract, into a contract. Now, what happens is that for you to prove that yes, this is what is going on, the injured party or the victim, so NB, the modern doctrine requires that, the modern doctrine, because you can't just go to the court and say I was forced. So modern doctrine requires that the victim be subjected to pressure amounting to compulsion of will, amounting to compulsion of the will, and that the pressure was illegitimate. And the pressure was illegitimate. So physically you are being threatened. Now, to confirm if really you are duressed, then there are a couple of questions that we need to ask. If we can say that, okay, it's a compulsion of the will of the person, then before we can establish, because you don't just go to court and say, hey, he forced me to sign into the contract. No, there are certain questions we need to ask ourselves. Number one is, so key questions to validate duress. Key questions to validate duress. One, did the victim protest? Did you beg for your life? Oh, please, I cannot do this. You're going to kill me. Did you protest? Did you try to fight back? That's the first thing. Did you protest? If you didn't protest and they say it's no, you go and do it, that means you entered into it willingly. Now, somebody will say, okay, you have been threatened, then you protest, then they will kill you. No, but at least we want to see, because something that is against your will, you don't do it at a go, like on a silver platter like that. Definitely, there should be some element of what? Protest. That's the first thing. Did the victim protest? Two, was there an alternative route available for the victim? Was there an alternative route or option available to the victim? That's the second question. Now, if you protested, could you have done something else? Maybe run away, report to the police station? Under that circumstance, is there any alternative option available for you? Was there? If there was none, then really you were forced. But if you had other options, why the heck did you allow yourself to be forced into signing a contract you don't want to sign? That's the second thing. Then, third, was the victim independently advised? Was the victim independently advised? So, did someone advise the victim on the decision that he or she was making? This is what you need to understand in relation to that. So duress renders a contract voidable. It means the contract is valid, only that there is that element of willfulness that is not in it. But unless otherwise you can prove that you were forced, the court will still rule in the favor of the other party who supposedly, allegedly forced you into signing the contract. So duress makes the contract voidable, meaning the contract is valid but lacks some technical elements to make it enforceable in the court at the end of the day. So if you take it to court, you have to prove I was pressured. You have to prove I had no other option. You have to prove that I was advised by somebody that is the only option I have available. If you can prove, then the court will DWASM for you and be with on your side. But if you cannot prove that you didn't protest, you cannot prove that, oh, you had alternative routes and you decided not to exercise them, then definitely you can't do anything about it. That is the idea about duress. Then undue influence. Undue influence. Now, undue influence, it's simply where there is, it's also a form of force, but then it could be indirectly, it could be a conflict of interest that is coming in a case. So let's say that, for instance, a loan is being secured by a person who is not in a commercial arrangement with the debtor, and then the lender is put on notice, but that undue influence may be the lender is put on notice. So what does that mean? Let's say that, like I mentioned, A and B are there. Then A wants a loan from a bank, but then B has no relationship of that particular thing that is going on. And for instance, A goes for the loan and had used B as a guarantor for the loan. Now remember, B has no relationship with the loan company A, so he is not supposed to enter into the contract. But then the loan company will say that, oh, we thought the person informed you about it, and I actually faced an issue like that. Somebody used my name as a guarantor for a loan. I was there, I got an email as tell the people, otherwise we would take legal action. And I was like, what the heck? Borrowed money with me, guarantor, you will take legal action. Legal action, and like I was furious. So I sent a message to the person who supposedly used my name, and like it has ended our relationship. Like that's it. I sent a message to the person. The person has been trying to call me. I just told him, make sure you pay the money. That's all. Because if you can use my name because you have my name and you have my details, that doesn't mean you can just go and fill a form somewhere. And the bank or some of these lending companies, how can you give a loan to somebody when the guarantor hadn't signed anything? Then you are sending me a message. Later on, they call me and said that, oh, it's not that they will take me to court. They will take the person to court, but they are just informing me to tell the person so that the person will pay the money on time, so they don't have to take the person to court. I said, what do I care? So that is an issue about undue influence. So you realize that I am entering into contracts with them without any direct force, without any direct relationship. So that is the concept about undue influence. So it refers to a circumstance where a party enters into contract not willingly or willfully, due to an action or a perceived relationship Now the solution available here under this will be definitely recession. You just let it go, because I mean, whatever has entered has entered. You can sue the person who is doing this against you is an indirect force that you are having, can sue the person who is doing this against you. That is the idea about undue influence. Then the last one is illegality. Now, this is where the subject matter of the contract is what? Illegal. So if the subject matter of the contract itself is illegal, that means that it cannot be entered into, or it cannot be enforced in the law courts. Now, there are public policies that dictate what should be legal and what should be illegal. In other words, any contract, so any contract tending to be one, corruption in public life, 2, promoting sexual immorality, 3, prejudicial to the administration of justice, trading with an enemy in wartime. These are all referred to as illegal transactions. So like the way Afghanistan is turmoiling like that, then you go and do any business and they don't like the Russians, they don't like the Americans, the Taliban people, they don't like any of these people. Then you go and enter into contract with any of that company, and something happens at the end of the day and you want to exercise the law, or that foreign company is in Afghanistan, for instance, and you are taking the company to court. In such circumstances, all foreign companies who are at war, or who they are at war with, they see them as what? Enemies. Here, there is no solution available. Either you keep quiet, or when you go to court, both of you will be jailed because the subject matter is illegal. So you keep quiet and say, hey, Charlie. Or maybe, so like for instance, at this point here, there's an issue in court, then you go and see the judge, and you give the judge goods, or you give the judge some stack of cash. And the judge came, and the judge gave the judgment, and it didn't go to your favor. What the heck? Then you just have to send some people to visit the judge so that you take him out. Because you can't take the judge to court. You can't take the judge to court. Like, because the subject matter, it's illegal. These are what we refer to as vitiating factors. When these factors are present in a contract, they cripple the contract, and they invalidate the contract, and the contract cannot be enforceable in the law court.